All right, good morning, everyone. I'm Judge Jackie Powell, and we're in first appearance court. Today, we're going to talk about whether I found probable cause to detain you and then to talk about release conditions. Today's not your trial date, so today's not the day that you are going to discuss your case or talk about the facts of your case. And in fact, I advise you not to speak about your case on the record because everything in this courtroom is being recorded. I do have in the courtroom with me an attorney from the state attorney's office, Mr. Eric Linder, an attorney from the public defender's office, Mr. Brian Reedy, and we also have an attorney over at the main jail. When I call your name, I'm going to ask you to step up to the podium, and then we are going to address each case individually. If your attorney's here, they will speak on your behalf, whether it's an attorney from the public defender's office or an attorney from the private sector. There are a few people this morning that I'll just check to see if they are in custody this morning so that we can address them first. So, good morning, Mr. Romero.
Good morning, Judge. How are you?
I am well. So if you can tell me, is William Green, who's on page 12, back in custody? No?
Still alone.
Okay.
No. I'm being advised no, Judge.
All right. And then on page 26, we have Kirby Telsine. Is Mr. Telsine?
Mr. Telsey? No.
Okay.
He's not here as well.
And then on page 13, Oscar Zuniga.
13. He's here, Judge.
All right. Can we address Mr. Zuniga?
Yes, Judge. Come on up, Mr. Seneca.
All right, Mr. Zuniga, you're before the court this morning for count 1, fleeing and eluding law enforcement. Count 2 is driving while license suspended. And count 3 is unlawful speed. I do find probable cause, and I'll hear from the parties as to bond.
Judge, at this time, I'm not going to be making any requests after speaking with Mr. Zuniga, and he did provide me the phone number of his family, and I intend on calling the family after court.
Okay. State, did you wish to be heard?
No, Judge.
All right, Mr. Zuniga, your bond is $2,500. Good luck, sir. And then Paul Leith on page 15.
Judge Paul Lee, we were going to request that he come to the second magistrate.
Okay.
We've already called.
Judge, I'm being... Oh, they know? Okay.
All right, so he has already been pulled and he'll be in for the afternoon? All right, so he'll be reset. Thank you. All right. You know what? All right, on page 1 at the bottom is John Ingram.
Yes, Mr. Ingram is here present. He advises he has private counsel, Judge.
He does.
Mr.
He has a private attorney who's asked to have him reset to the afternoon. So we'll reset him for the PM.
I spoke with Mr. Nevins.
We spoke to Mr. Nevins as well. So.
Okay, all right.
All right. He just called us, Mr. Reedy.
I spoke to him.
Yeah. All right. So let's start now from page 1. Amos Davis.
Mr. Davis is here, Judge, and he is approaching. Come on up, sir.
All right, Mr. Davis, you're before the court this morning for 1 count of aggravated battery on a victim who's pregnant. Count 2 is domestic battery by strangulation. And count 3 is battery causing bodily harm, domestic violence. I do find probable cause, and I'll hear from the parties as to bond.
Your Honor, I'm going to be requesting a $15,000 bond on count 1. My concern the allegation that he kicked his pregnant girlfriend in the stomach, $10,000 bond on count 2 for the strangulation, $2,500 bond on count 3, no victim contact, pretrial release with a GPS monitor. In 2009, Mr. Davis was convicted of domestic violence battery against a different alleged victim. 2007, he was arrested for child abuse. The charges dropped. He had a resisting without violence and unlawful use of false name in 2005. Conviction for delivery of cocaine in 2005, sentenced to 16-month state prison. Possession of cocaine 2003 with a VOP, 16-month state prison. Nothing further.
Okay.
Judge, in speaking with Mr. Davis, he's not financially going to be able to afford to post I believe if my math is correct, around $27,500, which the state is suggesting. Mr. Davis has been residing in South Florida his whole entire life. He's 37 years old, Judge. He just right now got employed about a month ago. He's working for a company called Coastal Railings, where they fabricate metal. He's just been there 1 month. It's a good job. He's making only about $12 an hour, but unfortunately, he has no financial assets. He has no money in the bank. Nothing to come close to being able to post a monetary bond, which the state is suggesting. Judge, he's advising me that he's disputing these facts, Judge. We're going to be asking on his behalf, Judge, a $2,000 bond on count 1, a $2,000 bond on count 2, a $1,000 bond on count 3 for a total of $5,000, and we wouldn't object to standard pretrial release.
All right, thank you, counselors. I do find probable cause, and I do find that a reasonable bond based on the allegations in this affidavit as to count 1, $15,000, count 2, $10,000, count 3, $2,500, with level 2 GPS, no victim contact. Richard Winter.
Mr. Winter, come on up, please. Please approach, Judge.
Yes. Mr. Winter, you're before the court. Count 1, touch or strike domestic battery. Count 2, resisting officer without violence. Count 3, possession of alprazolam. Count 4, tampering in a first-degree felony proceedings. I do find probable cause, and I'll hear from the parties as to bond.
Your Honor, I'd be requesting a $5,000 bond on count 1, $1,000 bond on count 4. I'm concerned about the level of violence. Among other things, he's alleged to have slammed the victim's head multiple times against a glass door. The victim, for safety, retreated to her daughter's room, hid inside her daughter's room where she was sleeping, and then ran outside to seek refuge at a neighbor's home. In 2015, Mr. Winter was arrested for domestic violence battery against a different alleged victim that was dropped. Reckless driving in 2015. Nothing further, Judge.
State defense.
Judge, in speaking to Mr. Winter, he's disputing the allegations which the state has informed us of. He's 27 years old, been here his whole entire life. He's self-employed. He lays tiles. He makes on an average about $200 a week. He does have family that live in our community. He knows and will abide by the court order as far as no contact and will be living separate and apart from the alleged victim. Judge, we're going to be requesting on count 1 the $1,000, and on count 4, which the state is suggesting as far as the $1,000 bond is reasonable. We're also going to be requesting a photo order be signed.
Okay.
Say phone or photo?
Photo.
I'll sign that photo order. I do find probable cause as to count 1. The bond is $5,000. Count 2, 100. Count 3, 1,000. Count 4, 1,000. No victim contact. Alexander Torres.
Judge, our Spanish interpreter is here.
Okay, who needs a Spanish interpreter?
On page 16, Mr. Trujillo.
Okay, on page 16, Elio Trujillo.
Yes, Judge, he's being brought.
Madam Interpreter, in the meantime, can you raise your right hand? You swear or affirm to translate from Spanish to English, English to Spanish?
I do. Good morning, Your
Good
Honor.
morning.
Solange Sands, S-A-E-N-Z.
Thank you, Ms. Saenz.
You're welcome.
Sometime. I think
He's coming in next.
that the
Sure.
reach after the phone.
All right, Elio Trujillo,
Elio Trujillo,
you're before the court this morning for one count of DUI.
ha comparecido en la corte hoy por una acusación de DUI, conducir bajo los efectos de alcohol o de drogas,
As well as a violation of a felony probation.
y también por no cumplir con las condiciones de su probatoria de delito mayor,
The probation violation is a no bond hold.
por tener esa acusación de no cumplir con las condiciones de probatoria, tiene una retención sin posibilidad de fianza.
And you will be before your felony judge tomorrow at 8:45 a.m.
Se va a presentar en frente del juez que está a cargo de ese delito mayor, ese caso de delito mayor, y eso va a ser mañana a las 8 de la mañana.
I do find probable cause,
Decidimos que existe motivo fundado.
and the bond on count one is $1,000.
La fianza para el primer cargo va a ser $1,000.
Good luck, sir.
Buena suerte, señor.
Is there anyone else who needs a Spanish interpreter?
¿Alguien más que necesite la ayuda del intérprete?
Judge, I'm being informed, I believe that's it.
Okay. At any of the other facilities, North Broward, Conti, or Paul Ryan?
Not as far as I know, Your Honor.
All right, thank you. Thank you, Ms. Saenz.
My pleasure, Your Honor. Have a wonderful day.
You too. All right, we'll go back to our docket. The order, Alexander Torres,
Mr. Torres is approaching, Judge.
okay? All right, Mr. Torres, you're before the court today for 3 counts of possession of THC. 1 count 4 is possession with intent to sell, manufacture, or deliver cannabis. Count 5 is resisting without violence. Count 6, improper parking. And count 7 is domestic battery by strangulation. I do find probable cause, and I'll hear from the parties as to bond.
Your Honor, based on the allegations on the strangulation charge, I'd be requesting a $10,000 bond in order of no victim contact. He has a resisting an officer from 2018 out of Palm Beach. When he was arrested on that offense, there was also an outstanding capias for a failure to appear. He had a couple other previous failures to appear out of Palm Beach County. Nothing further.
Judge, we're going to be requesting on count 7 a $2,500 bond. Also on the possession of THC on counts 1, 2, and 3, we're going to be requesting an ROR on those counts. He's 27 years old, been here his whole entire life. He is working. He works as a barber. He's been doing that for about 1 year now, or he makes approximately $100 a day doing that. He will be living separate and apart from the alleged victim. He does have a family that he's going to be reaching out to post his monetary bond, but from what he advised me, they're going through a tough time as far as their financial resources, so that's why he can only afford to post the $2,500 bond, and that's the basis of our request, Judge.
All right, I do find probable cause as to counts 1 through 5. The standard bonds will remain. Count 6 is not for magistrate. Count 10, I'm going to impose a $10,000 bond. That's going to be with a level 2 GPS. No victim contact. Nicholas Anderson.
Mr. Anderson, come on up, please.
All right, Mr. Anderson, you're before the court for aggravated battery with a deadly weapon. I do find probable cause. I'll hear from the parties as to bond.
Your Honor, I didn't see any priors for Mr. Anderson. That being said, I'm going to be requesting a $15,000 bond, pretrial release with a GPS monitor, no victim contact, no weapons, firearms, ammunition. I'm concerned not only for the victim's safety, but Mr. Anderson's safety, not just based on the allegations of the aggravated battery with the knife, but Mr. Anderson's actions surrounding that incident.
Judge, as you heard, this is Mr. Anderson's first arrest. He's a registered voter here in Broward County. He's 25 years old, been here his whole entire life. At this time, unfortunately, he's unemployed. He's looking for work. He's going to be reaching out to his mother to help post his monetary bond. From my understanding, and she's a caretaker. He believes that maybe if the bond were somewhere around $5,000, he could afford to post that. So that's what we're going to be requesting, Judge, a $5,000 bond on Mr. Anderson's behalf.
Mr. Romero, based on your interactions with Mr. Anderson, is there any concern for a mental health screening? Do you think we need a mental health screening?
One moment, Judge. Not at this time, Judge.
All right. Based on the allegations, I do find probable cause. I am going to impose a bond of $5,000 with a level 2 GPS, no victim contact. Ernst Simon.
Simon, come on, please.
This is kind of house. Person you got right there.
Mr. Simon, you're before the court for count 1, robbery by sudden snatching without a firearm or weapon. Count 2 is touch or strike battery. I do find probable cause. And I'll hear from the parties as to bond.
One moment, Judge. Your Honor, I'm going to be requesting a $5,000 bond on count 1, a $2,500 bond on count 2. Mr. Simon was arrested on Friday, March 22nd on a loitering and prowling. He bonded out. He and co-arrestees were found loitering in an area where there had been a recent rash of car burglaries. He does have juvenile priors, felony juvenile priors. and I do have a concern for the safety of the victim in this case.
I would ask the court to disregard the state's argument about Mr. Simon being arrested for loitering in an area where there had been a rash of car burglaries, unless the state has evidence to support the contention that Mr. Simon committed a burglary of a conveyance. That is purely inflammatory toward this court, and there's no underlying evidence to support the allegation that was just made.
Your Honor, I was reading it directly off the probable cause affidavit from his arrest. I would be more than happy to show Your Honor and Mr. Reedy a copy of that probable cause affidavit.
Even if it's in the probable cause affidavit, it's still irrelevant. Mr. Simon is not charged with any burglary of a conveyance, and I would ask the court not to consider that language in determining an appropriate bond for Mr. Simon on these charges.
All right, based on the allegations in this probable cause affidavit that's before the court today, the allegations are that he snatched a necklace, golden diamond necklace at the value of $1,400, and then he also intentionally kicked and stomped the alleged victim's head 2 times against her will, took her cell phone, so based on those allegations, I do find probable cause. I am going to impose a bond of $5,000 on count 1 and $1,000 on count 2. No victim contact until further order of the court.
Judge, I'm going to ask you to consider on count 1, bond reduction from $5,000 to $2,000. He was just working at Pollo Tropical. Unfortunately, he lost his job, and he was only making $8.50 an hour. Now he's currently looking for employment. He's been here his whole entire life. So financially, he's not going to be able to come up with the $5,000 for 1, so that's why I'm requesting a $2,000 bond for count 1.
I'm going to deny that at this time. Clinton Masses. Oh. Mr. Masses, you're before the court for 1 count of battery, second or subsequent offense of domestic violence. I do find probable cause, and I'll hear from the parties as to bond.
One moment, Judge. Your Honor, I'm going to be requesting a $20,000 bond, pretrial release with a GPS monitor, no victim contact. I have a concern for the community. I have a concern for this particular victim. Mr. Masses has a lengthy history of domestic violence allegations against, but not limited to, this particular victim. In 2017, he had a felony battery due to priors against the same alleged victim, was sentenced to just under 12 and a half months in Florida State Prison. What month is it again? He was released in July of 2018. 2014, possession of PVP, received the same sentence. In 2013, he was arrested for aggravated battery against a pregnant victim. That was against a different alleged victim, but it was domestic in nature. That was dropped. 2011, he was convicted of domestic violence battery against a different alleged victim, sentenced to 180 days in county jail. 2010, he was arrested for aggravated battery, great bodily harm, and aggravated battery against a pregnant victim. Those charges were dropped. In 2009, another arrest for battery, that was dropped. 2009, possession of cocaine. 2008, possession of cannabis with intent to sell or deliver. 2005, escape, 40-month state prison. 2005, possession of cocaine, and 2004, possession of cocaine, 40 months in state prison. 2003, was convicted of battery. And 2001, leaving the scene of an accident. One moment, Judge. He's had multiple priors earlier than that. Another escape in 1989 where he was sentenced to 3.5-year state prison. I would also direct the court's attention to Mr. Mass's booking sheet where the court can see how many aliases he's used in the past.
Judge, the $20,000 bond is something Mr. Masses doesn't have, nor can he contact anyone that could come up with the premium using the services of a bondsman. We're going to be requiring $2,500 half. Also, Judge, we're going to be asking for a photo order so we can photograph the injuries that Mr. Mass has sustained as well.
All right, I will sign that photo order, I believe.
Photograph.
All right. Based on the allegations in this affidavit, I do find probable cause, and I do find that a reasonable bond or release conditions will be a $20,000 monetary bond with, it's going to be a level 1 GPS. No victim contact until further order of the court. Good luck. All right, Mr. Shade, you have 2 matters before the court today.
Mr. Gagney, who's in the main jail.
On page 8, Norman Gagney is represented by Mr. Shade.
Mr. Gagney, come on out. Be careful, sir.
Judge, for Mr. Gagney, he doesn't have a significant history in the city of, Broward County. Really the last 2 years, mostly all alcohol related. There's 4 cases here. The city of Hollywood still offer a time served bail.
All right, Mr. Gagney, can you hear me, sir?
Yes, ma'am.
All right, Mr. Gagney, you're before the court for its 5 misdemeanor KPS's municipal ordinance violations. And your attorney is here, Mr. Shade.
Okay.
And he tells me that the city has offered adjudication and time served to resolve your case. And so I want to know if that's what you wish to do, sir.
Yes, please.
All right. Mr. Gagney, what plea do you wish to enter?
No contest.
All right, sir. I accept your no contest plea and your sentence is adjudication and time served. Good luck, sir.
Mr. Gagney, try not to go back to those same areas, okay? Because you're just gonna get arrested again, okay? The city of Hollywood doesn't want you in those areas, so just be careful where you go and drink.
Okay.
All right, good luck.
Thank you.
James Roberts, who's on page 10.
Judge, he has a state case as well.
He's approaching, Judge.
Okay. Mr. Roberts, you're before the court for count 1 is trespassing and count 2 is a misdemeanor KPS and a municipal ordinance matter. What does Mr. Roberts wish to do?
Judge, in speaking to Mr. Roberts earlier today, he wishes to ask the court if the court would consider resolving these matters today.
That's the same with this city case as well.
Okay.
I mean, Your Honor, the offer is going to be time served. It's been a little while since we've seen Mr. Roberts, because there was a time last year where we were seeing him weekly. I hope we don't see him again for something like, this for a little while again.
All right, Mr. Roberts, you've managed to stay off the streets for a long time, so I hope that you can do that again.
Yes, ma'am.
All right, whatever it is that you were doing to stay off the streets, I think you should go back to doing that.
So what
time? You think so? You think that's gonna work?
Yes, ma'am.
All right. So what plea do you wish to enter this morning?
Guilty.
Guilty or no contest?
No contest.
All right, I'll accept your no contest plea, and I will sentence you to adjudication and time served. And like the other gentleman, I'm going to tell you, you've got to stay away from these areas where, the officers know that you're trespassing, okay?
Yes, ma'am.
All right, sir, good luck.
Thank you, Judge.
So much.
All right. All right, David Post. His out-of-state hold was dismissed, so we have no need to reset him. Everything's done with this. Okay. Karen Rosman,
I've been informed she bonded, Judge.
thank you. Stephanie Britas,
Paul Ryan.
thank you. All right, Ms. Britas, you're before the court. It's an add charge, charge 5 for grand theft auto. I do find probable cause. Is Ms. Britas being held on other charges at this time?
Judge, she's posted bond on the other charges, counts 1 through 4.
How much was the total bond?
It was, what did I say it was, Ms. Britas? $4,000?
500 was one the 1,000 or two.
$2,500.
Is it
25? Is it
Thank you,
25?
Mr. Lender.
No problem. 2,500.
Okay.
Judge, I'd ask you to consider releasing Ms. Britas, either pretrial release or on her own recognizance. Her friends got the money together to bond her out on counts 1 through 4, which I still see as a $4,500 bond, at least according to BSO picks. The bond on this case, I don't know if they're going to be able to come up with that additional money to bond her out. I think they may have exhausted their resources. So I'd ask the court to consider an ROR. I also think that there's an issue as to whether or not there was permission to use the car. I think that there are some issues going to be raised in that. I know what the victim said in the probable cause affidavit, but I think that there's going to be some issues there.
If Your Honor wants the ROR because the other bonds are posted, okay, that's one thing. But just to start speculating, well, despite the sworn statement where the victim says, no, my car was stolen, don't believe that. Believe that, she had permission. That's a whole other thing.
All right, Ms. Britas, I do find probable cause, and I'll ROR you on this count. Good luck.
Thank you, Judge.
Mr. Joseph?
Yes, Your Honor. How are you?
No problem, Your Honor.
Thank you. Good morning.
Good morning,
Miss-
Good morning, Your Honor.
Good morning, Ms. Joseph. You're before the court for 1 count of grand theft,
Yes, ma'am.
and I do find probable cause, and I'll hear from the parties as to your bond.
Your Honor, I'm going to be asking the court to consider pretrial release for Ms. Joseph. I don't know if the state has an objection to that. Oh, no, I'm sorry. Wait, no, I'm not. She spoke with, and I tried to reach a friend of hers, and her friend says he's going to be able to post the bond, so I'd ask the court to leave it where it is.
Okay. Mr. Linder, do you wish to be heard?
No, Judge.
All right. Ms. Joseph, your bond is $1,000. Good luck.
Yes, ma'am. Thank you.
Okay.
Good luck.
Katie Peterson?
North Broward.
All right, Ms. Peterson, you're before the court. Count 1 is possession with intent to sell, manufacture, or deliver cannabis. Count 2 is possession of drug paraphernalia. Count 3 is an out-of-state felony hold.
Your Honor, in light of the out-of-state hold, I'd ask the court to leave the bond on count 1 in place.
Okay, I do find probable cause, and your bond on count 1 is $1,000, and you should be before the extradition court either Tuesday or Thursday of this week in regards to your out-of-state hold. Okay, good luck.
Yes, thank you.
All right. Danielle Carrero?
North Broward.
Good morning.
Good morning, Ms. Carrero. You're before the court. Count 1 is petty theft. Counts 2 through 5 are felony violation of probation. Those are all no bond holds. I do find probable cause. Your bond on count 1 is $25. And you'll be before your division judge tomorrow at 8:30 a.m. Good luck.
Thank you, ma'am.
Okay.
Thank you.
Good luck, Danielle.
Joseph Sullivan Smith? All right, Mr. Sullivan Smith, you're before the court. Count 1 is criminal mischief. Count 2 is DUI. Count 3 is refuse to submit to DUI test. I do find probable cause, and I'll hear from your attorney, Esteban.
Judge, at this time, Mr. Smith did give me the phone number of his girlfriend, who I intend on calling after court to post his monetary bond.
Okay?
Your Honor,
Yes.
Mr. Sullivan Smith is currently on pretrial supervision in case number 19005513 MU10A, driving under the influence. At this time, we're going to request a revocation of his supervision.
State, aside from this other DUI, what kind of prizes Mr. Smith have?
One moment, Judge. Anything I can sign off. It's not him. That's the only Smith you have? Sullivan Smith. Michelle, do you have any notes? Because he's not on our list.
In addition to that DUI, Your Honor, he currently has a pending warrant out of the state of, out of the state of Rhode Island that was issued January 24th, 2019.
All right, on case number 19005513 MU10A, Mr. Sullivan Smith is on pretrial release on a charge of driving under the influence. At this time, I am going to revoke the pretrial supervision on that case. And I'm going to impose a $2,500 bond as to that charge.
Thank you, Your Honor.
On the new arrest, finding probable cause, I am going to impose a bond of $1,500 on count 2.
Your Honor,
Yes.
in light of the fact that he has now 2 pending DUIs, the state would be requesting a TAD monitor.
Right. So there'll be a $1,500 on count 2 with a TAD monitor. All right, good luck, sir. Brian Pierce.
Mr. Pierce is approaching, Judge.
Okay.
Sir?
Good morning, Mr. Pierce. You're before the court for one count of DUI. I do find probable cause, and I'll hear from your attorneys as to bond.
Judge, this is his first arrest ever. We're going to be requesting an ROR. If not, in the alternative, Judge, we're going to be asking for a phone order so that he can contact his family, post his bond.
Okay. State?
I'm just checking to see if there's any history, Judge. Mr. Romero advised how long he's lived here?
No, I don't believe that was,
Okay, I just didn't know, well, because that's the only thing I'd want, because it shows 0 months of residence. He was driving on a Bahamian driver's license, so I don't know how.
all right, I am gonna leave the bond in place, and, I will sign that order for, his phone records. Dennis Carroll,
Mr. Carroll is approaching. Come on up, sir.
okay, Mr. Carroll, you're before the court for possession of cannabis 20 grams or less, and count 2 is a misdemeanor capias. Also on a possession charge. I do find probable cause, and I'll hear from the parties as to bond.
Judge, in speaking, Mr. Carroll, no one's going to be able to afford to post his bond. He gets disability. He gets approximately $750 a month. I asked him as far as the count 2, as far as why he missed court. He just didn't. He forgot his court date. Judge, he lives locally here in Deerfield with his mother. We're going to be asking for Mr. Carroll to be released on pretrial release on these 2 cannabis offenses.
Your Honor, I would object to any non-monetary release. I mean, he was just arrested March 10th on 3 separate capiases for 3 separate possession of cannabis cases. If he's interested in resolving the matters, he offers to be a withholding court cost on each case.
So he has 3 open cases at this time?
No, he resolved them when he was arrested in earlier last month.
Okay. And those are all drug charges?
All possessions of cannabis.
Okay.
Judge, in speaking, Mr. Carroll, I did advise him as far as the state's offer. At this time, he wishes to accept the state's offer, Judge.
All right, Mr. Carroll, do you understand everything that has been explained to you by your attorney?
Yes.
And what plea do you wish to enter, sir?
No contest.
All right, sir, I accept your no contest plea, and your sentence is withhold, adjudication, and court costs. Good luck. Yes. Renee De La Rosa.
Mr. De La Rosa is approaching, Judge.
Okay. Mr. De La Rosa, you're before the court for 1 count of trespassing, and I do find probable cause. What does Mr. De La Rosa wish to do?
He wishes to resolve this case today, Judge.
All right. State, do you have an offer for?
Yes, Your Honor. It's a time served, no return. Chances are that offer won't be available if he trespasses on the same individual's property again, so just so he's aware.
Wishes to accept the state's offer, Judge.
All right, Mr. De La Rosa, what plea do you wish to enter, sir?
No contest, Your Honor.
All right, I accept your no contest plea. Your sentence is adjudication and time served. No return to this location. Do you understand that, sir?
Your Honor, all my clothes are there.
All right, well, if this is somewhere where you lived, you can return one time with law enforcement to go pick up your stuff.
All right, thank you.
Alexandre Nosin.
He's here, Judge, at me. He's approaching, and Judge, he's proceeding pro se.
Okay. Mr. Nosin, you're before the court. Count 1 is resisting without violence, and count 2 is a municipal ordinance violation for a noise disturbance. I do find probable cause, and at this time, I will hear from you in regards to setting your bond. Do not talk about your case. I only want to hear about what you need to let me know in regards to setting your bond. What is going on here? Do you not speak?
I do.
Okay, so is there something you wish to say?
Well, we're on the record. Is that correct?
That's right.
All right. Second thing I would like to establish is I'm not really comprehending the procedures that are happening currently right now.
Okay.
If I recall correctly, we shouldn't be at the state right now because of the fact that there was an unlawful arrest and detainment that occurred. So through the whole processes that's already happened, I've been exercising my right to remain silent.
Okay.
Due to the fact that we're on the record currently right now, I just know that there should be a procedure that we're supposed to go through in order to establish a comprehension on both parties' behalf on how to proceed forward.
All right. I'm not quite sure what you're talking about. You have been arrested, and now this is the first stage. You are at first appearance. So I'll hear from the state. State, do you, is there any priors? Is there anything you wish to let me know in regards to setting the bond?
As far as Broward, he had a felony possession of cannabis in 2010, a resisting without violence in cannabis in 2009. I wasn't going to be asking for any kind of modification, Your Honor. However the court sees best to proceed, I'm fine.
All right. Okay. So, Mr. Noyson, in regards to count 1, there's a bond of $100. I am going to leave that in place. On count 2, which is the municipal ordinance charge for noise violation, noise disturbance, no bond is required, so your total bond, sir, is going to be $100. Good luck.
I don't understand.
All right. Patrick Wells. Mr. Wells, you're before the court. Count 1 is not for magistrate for not wearing a seatbelt. Counts 2, 3, and 4 are misdemeanor capious matters. Counts 2 and 3 are no bond holds, and count 4 has a $500 bond attached to it. I do find probable cause. You will be before your division judge tomorrow at 9 a.m.
Your Honor?
Yes.
I would, just a thought.
Yes.
About transferring Judge Gottlieb's case on charge 4 to Judge Lerner Wren, since it looks like the other 2 cases are before her in MI.
He has, counts 2 and 3 are before Judge Lerner Wren?
Yes, ma'am.
All right, so we can, have count 4.
Judge, Mr. Wells, in speaking to him, he believed that these cases were in drug court. I know they're trespasses, so I don't know how they made their way to drug court, if in fact that's correct. Or from what Mr. Lunder just said, it's in front of Judge Lerner Wren. Is this in mental health court?
Yes.
Port took the cases so that I can go to Bark. I've been in Bark for 6 months. So he took all these cases. I didn't even know I had cases.
All right, so I will leave everything in place, and he can make transfers from his division judge.
I'll advise her, Jay, that Your Honor's transferring the third case.
My last request, because in speaking to Wells, he wants me to mention this right now. Part of the condition, from what he was advised, he was ordered to Bark. He's been there for 6 months. He's been getting tested. He has a curfew at 10 p.m. Right now, he managed to get a good job. He works at a company called Compass Carriers, where they load trucks. Judge, he doesn't want to risk losing his employment. He's asking the court if there's any way the court can consider imposing pretrial release on these cases so that he could not lose his job and not lose where he's living, which would be at BARC.
And I have a voucher through BARC, through the courts, to stay at Salvation Army.
All right,
And
so I am not going to make any changes this morning. He has 3 misdemeanor capious matters. He can appear before his division judge, and they can resolve all those 3 issues in whatever way the judge sees fit tomorrow. Douglas Farmer. All right, Mr. Farmer, you're before the court for count 1 is a petty theft and count 2 is trespassing. I do find probable cause, and I'll hear from the parties as to bond.
Judge, Mr. Farmer is asking if the state has a plea offer for him.
Okay.
Offered be time served on both counts, no return to that Publix.
He wishes to accept the state's
All right, Mr. Farmer, do you understand everything that's going on?
Yes, Your Honor.
And you understand the offer that has been extended to you?
Yes, Your Honor.
What plea do you wish to enter, Mr. Farmer?
No contest.
All right, sir, I accept your no contest plea and sentence you to adjudication and time served on both counts. Good luck, sir.
Your Honor, North Broward is asking for a case to be called out of turn.
Yes, what case is that?
It's Mr. Joel Valley. He's the last case on your docket.
Okay. All right, good, thank you, you're welcome. Mr. Valley is before the court. We previously found probable cause for count 1 and 2, burglary, count 3 is grand theft, counts 4 through 7 is felony violations of probation. I don't know if he's been to his division judges yet, so it looks like he
Actually,
should have been there
Judge,
today.
he had a court date set for this morning in front of Judge Porth.
Okay.
But I guess they left him in North Broward because of his magistrate hearing today.
All right, so on counts 1 and 2, I'm gonna impose a bond of $5,000, and on each of those counts, and then count 3 is $1,000, and then hopefully he can get to his division judge as soon as possible for the violation of probation matters which are no bond holds.
Yes,
Good
Judge.
luck, sir.
All right. Good luck, Joel. Hang in there, okay?
Okay, Deputy, thank you. Sarlik Richardson. Sarlik.
Is here present, Judge?
Mr. Richardson, you're before the court for 2 traffic capious matters. Well, count 1 is a ROR. And count 2, there was a bond of $500 attached to that. That's a failure to register and operating without a valid license. What does Mr. Richardson wish to do?
Judge, it's being Mr. Richardson. He wishes to see if the court's going to resolve these matters today.
All right.
So withhold court costs, Your Honor.
On both?
Yes.
All right, Mr. Richardson, the state is offering a withhold adjudication and court costs to resolve your case, your both charges. Do you wish to accept that plea offer?
He wishes to accept the state's offer.
All right, so Mr. Richardson, what plea do you wish to enter?
What's your plea? No contest.
All right, sir, accept your no contest plea. Your sentence, sir, will be a withhold adjudication and court costs. Good luck, sir. Hunter Moser.
Mr. Moser's approaching, Judge.
Mr. Moser, you're before the court for resisting officer without violence. I do find probable cause. And does the parties wish to be heard as to his bond?
Judge, in speaking with Mr. Moser, he wishes to ask the court to resolving this matter today.
Offers to withhold court costs, Judge.
Withhold court costs. Do you wish to accept the state's offer? Basically means the case is over with. You don't have to come to court. You'll be on your criminal history. However, there's court costs. The judge will give you time to go ahead and pay that court cost. I believe it's going to be
6 months.
200, 300. I'll ask right now. Yeah, Judge,
It's $293 for the Madam Clerk. $293.
$293. All right, cool. And he's requesting if the court could give him 6 months to pay the court cost. Judge.
Okay. All
And he
right.
wishes to accept the state's offer.
All right. Mr. Moser, what plea do you wish to enter?
No contest.
All right, sir. I accept your no contest plea. Your sentence is a withhold adjudication and court costs, and I will give you 6 months to pay the court costs. Good luck. Damon Sands.
Mr. Sands is approaching, Judge.
Okay. All right, Mr. Sands, you're before the court for 2 misdemeanor capious matters. I do find probable cause. I also have been advised that your bonds have been posted. Good luck, sir.
Yep.
Earl Brewer Sanders.
Mr. Brewer Sanders, come on up.
Mr. Sanders, you're before the court for 2 misdemeanor capious matters. I do find probable cause.
Judge, in speaking Mr. Brewer Sanders, he wishes to ask the court if the court will consider resolving these matters today.
Okay. State, you have an offer from Mr. Sanders?
Yes, Your Honor. It would be a withhold court costs on both counts. No return to 1620 North Federal Highway in Hollywood. That's a quick stop.
Okay, Mr. Sanders.
Judge, he's wanting to accept the state's offer.
All right, Mr. Sanders, Mr. Brewer Sanders, what plea do you wish to enter?
No contest.
All right, sir, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is a withhold adjudication and court costs. And as you heard, no return to that quick stop at 1620 North Federal Highway. Do you understand that, sir?
My understanding, right now he's saying it wasn't a quick stop, it was a it's called Hollywood Market.
Do we even have it at? The accurate address is on Town Street.
It's 1620 North Federal Highway. The officer here has it Hollywood Market in parentheses quick stop.
Yeah, Hollywood Market.
Okay. All right. Thank you.
John Odom.
Mr. Odom? He's approaching, Judge.
Mr. Odom, you're before the court for a misdemeanor capious matter. The charge is trespassing. I do find probable cause. What does Mr. Odom wish to do?
He wishes to resolve this case today, Judge.
All right. State, do you have an offer from Mr. Odom?
One moment, Judge. The offer is a withhold court cost, no return to 1000 Pembroke Road in Hallandale Beach.
Judge, he wishes to accept the state's offer.
All right. Mr. Odom, what plea do you wish to enter, sir?
No contest.
All right, sir. I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence is a withhold adjudication, court costs, and no return to 1000 Pembroke Road. Do you understand that, sir?
Yes, Your Honor.
All right. Good luck, sir. Aaron Stegman. All right, Mr. Stegman, you're before the court today for charge number 4, which is a grand theft. I do find probable cause. I know Mr. Stegman what amount of bonds, total amount of bonds is he
He's
on?
actually on pretrial release with an Elmo, and from what he advised me, the pretrial release is having difficulty verifying an address. His father had a heart attack the day he was arrested, and is currently receiving treatment for that.
And I just want to advise the court, the first time he was arrested, that was a capias on a petty theft. He was sent to pretrial. Then he got charged with a separate grand theft and another petty theft. Then he was ROR to pretrial with the GPS. Now there's another charge for another grand theft. So, you know, the amount of thefts he's been involved with since down here is growing and growing. And while I certainly sympathize for his father, one moment, distinction. It would appear, based on these allegations, he was stealing with his father.
Yes, Judge, that's what the probable cause affidavit would indicate. This happened on February 17th of this year. I'd ask the court to place Mr. Stegman on the same conditions he's already on counts 1 through 3, and try and find a place for him to go if we can verify an address somewhere.
Is that he was on a level 2 GPS?
I believe so.
Okay. All right, so I'll release him under the same conditions, level 2 GPS. Pre-trial with GPS monitor, sir. All right, good luck. Curvins, Joseph.
Mr. Joseph has family members present, Your Honor.
Okay. Curvins, Joseph.
Your President, name, Judge?
Mr. Joseph, you're before the court this morning. Count 1 is a felony violation of probation, which is a no bond hold. Count 2 is driving while license suspended or revoked. There's a bond of $25 that's attached to that. Count 3 is an expired driver's license over 6 months. Count 4 is a traffic infraction, turning when it's not unsafe. That's not from magistrate. And then count 5 is a felony violation of probation for with a no bond hold. So you have 2 no bond holds from felony court. You will be going to court tomorrow to your felony judge at 8:30 a.m. And the bond on count 2 is $25. And no other bonds are required at this time. That's it. Good morning. All right. There's not much else I can do this morning. He's on no bond felony holds, and he'll be before his division judge tomorrow. Okay? All right.
Hang on 1 second, guys.
Virgil Stevens. From right there, you can talk to him.
Here's where he needs to, where he's going to be tomorrow. In court.
All right. Virgil Stevens.
Yes.
Mr. Stevens, you're before the court. Count 1 is grand theft auto, and count 2 is resisting without violence. I do find probable cause, and I'll hear as to bond.
Judge, I'm going to be requesting an ROR on Mr. Stevens' behalf. My understanding is this is his first contact with the criminal justice system as an adult. My understanding, Judge, he's been living here his whole entire life. He's 24 years old. He lives in Hallandale with his aunt. His aunt is retired. He gets Social Security. Right now, he's currently looking for employment, Judge. So if it's true and the state verifies that this is his first contact as an adult, that's why I'm requesting an ROR. If not, Judge, when he came in, I believe he had funds with them. I'm going to be asking the court to consider reducing the bond from $1,000 to $100 so that he can self-bond.
Okay.
What's that? Yeah, I see no priors as an adult that he's pled out, Your Honor. I'm relying on you. I don't have him on my list. Huh. Well, based on that, the state would oppose an ROR then. Being advised he has a pending burglary out of Dade County from January of this month. And I see he just nodded yes.
Judge, then I would be, or would consider reducing it to $100 so you can self-bond it.
All right, I'm gonna deny that bond reduction. The bond is gonna remain at $1,000. Saria Augustin. Mr. Augustin, you're before the court for one count of burglary on occupied structure unarmed.
Start looking this guy up, please.
I do find probable cause.
Yeah, please.
Oh, here is the bond.
I'm just putting his information in the system, Your Honor. If Mr. Romero has anything, we don't have to wait.
Judge, I'm going to be requesting a $1,000 bond on this third-degree felony. He's 24, been here his whole entire life. He works for a company that deals with irrigation, and he's also a handyman, where he makes approximately about $300 a week doing all that. He does pay child support. He has 3 kids. He lives in Boynton Beach with his mother. His mother is retired, and she's on Social Security. That's who he's going to be reaching out to post a monetary bond. And he believes using the service as a bondsman, his mom can come up if the bond was $1,000. That's what the defense is requesting for at this time.
Okay, I'm going to be requesting a $2,500 bond. I see multiple arrests, but I would note that he was just arrested January of this year in Palm Beach County on a capias for a failure to appear in court. And let's see. Only other request I would make, Your Honor, is no return to this listed business.
All right, so as to count one, I'm gonna impose a $2,500 bond and no return. Enrique Ramirez.
He's approaching.
Mr. Ramirez, you're before the court. Count one is burglary on occupied structure unarmed. Count two is a misdemeanor capias matter. I do find probable cause. Count two is a suspended driver's license offense, and he did not show up at calendar call September 5th of 2018. I'll hear from the parties as to bond.
Judge, I'm going to be requesting a $1,000 bond on count one. Mr. Ramirez has been here his whole entire life. He works for a landscaping company. He's been with that company now for 5 years, in which he makes about $80 a day. He lives in Boynton Beach with his mom. His mom works at a nursery. That's the person he's reaching out to post a bond, so we're going to be requesting a $1,000 bond on his behalf.
And, Your Honor, I'd be requesting the same $2,500 bond that you set for his co-arrestee. As you mentioned, he's here on a failure to appear. He also had a 2015 DUI out of Palm Beach County.
All right.
And no return, please.
All right, so I'll impose a $2,500 bond No return. It looks like he'll be before his, on the KPS tomorrow at 9 a.m. Kelly Brown. All right, Mr. Brown, you're before the court for count one is a parole violation. That's a no bond hold, and you should be going before the parole board. Count two is driving while license suspended, and the bond on attached to that is $100. I'll leave the bonds in place, and there's a no bond hold on count one. Good luck, sir. Jesse Keenall. All right. Sir, you're before the court for count one is possession with intent to sell, manufacture, or deliver cannabis. Count two is distribution, deliver amphetamine. Count three is possession with intent to sell or manufacture, or deliver cocaine. Count four is felony violation of probation, which is a no bond hold. You will be before your division judge tomorrow at 9 a.m. on the felony matters. And as to counts 1, 2, and 3, I'll leave the bonds in place. It's $1,000, $1,000, and $2,500. Good luck, sir.
Judge, I would argue that there's no probable cause as to the intent to sell aspect of count 3. I don't know if the state wants to discuss that. It's 8 rocks, which I think is certainly within the proximity of personal use.
Your Honor, I think taking the totality of the circumstances, I think there's enough evidence that there's intent to sell all the drugs found.
I couldn't disagree more. I think that there's plenty of evidence to support the contention that he may have had the intent to sell the cannabis because of the amount of cannabis found and because of the individual wrapped baggies of marijuana, no individual wrapped baggies of cocaine. And again, 8 rocks of cocaine is within the purview of personal use. So I would say that there is no probable cause to support that aspect of count 3.
My previous finding, I find probable cause as to all counts. John Pavlovich.
Come on up, sir.
Mr. Pavlovich, you're before the court for count 1, possession of MDMA, count 2, possession of heroin, count 3, possession of hydrocodone. I do find probable cause.
Judge, at this time, nothing from the defense. I intend on calling his girlfriend after court to post the bond.
Okay. All right, there's $1,000 on each count. Good luck, sir. Jason Ramirez. Mr. Ramirez, you're before the court for 1 count of grand theft. I do find probable cause, and I'll hear from the parties as to setting your bond.
Judge, one moment. I need to speak to Mr. Ramirez.
Okay.
Thank you, Judge, for giving me that opportunity to speak to Mr. Ramirez. We're going to be requesting pretrial release on his behalf. Right now, he lives in Miami Gardens with his wife, and they're supporting their 3 children. His wife, from what he informs me, cleans houses for a living. He works at the labor pool every day, so daily he works in order to go ahead and help provide for his family. Considering this is a nonviolent offense, Judge, that's why we're asking for the court to consider releasing Mr. Ramirez on standard pretrial release.
And Your Honor, I'm going to be requesting an increase of bond of $5,000, pretrial release with a GPS monitor. Mr. Ramirez is classified as a career offender in the state of Florida. He was released from state prison November 6th of 2018. He's gone to state prison for the following offenses out of Dade County: attempted strong-arm robbery, grand theft auto, robbery with a firearm or deadly weapon, burglary with assault, attempted carjacking without a firearm or deadly weapon, attempted strong-arm robbery, grand theft auto, robbery with a firearm or deadly weapon. He's received a 5-year prison sentence in the past and an 8-year and 10-month prison sentence in the past.
Judge, my understanding is, yes, he did, right now, did confirm it. He got released in November. He did a prison sentence for over 5 years. My understanding is, since he got out, this is his first contact. Right now, he's trying to change and provide for his family, and that's why he goes to the labor pool every day looking for employment. And that's why we're requesting pretrial release on his behalf.
I'm now asking for a $10,000 bond, considering he has an open grand theft in Dade County, and clearly any information he provided Mr. Romero was just false with intent to mislead the court. Well,
Judge, considering that, then we're going to be asking for the court to leave the standard bond in place.
All right. I do find probable cause. I am going to increase the bond to $5,000, and he'll also be on a level 2 GPS. And no return to Saks Fifth Avenue. I think this is at the Sawgrass.
yes.
Michael Deladon.
Come on up, Mr. Deladon.
Deladon. Mr. Deladon, you're before the court for count 1, disorderly intoxication, count 2 is trespassing, and count 3 is felony violation of probation. You'll be before your division judge tomorrow at 8:30, and the bond on count 2 is $100. Good luck, sir. Yes.
Mr. Deladon, he's on the docket charged with a violation of probation. Case number 17006316
Judge, I can't hear anything.
Oh.
He was released by the courts to pretrial supervision on that case number. At this time, we're going to request the revocation of his supervision based on the new law.
Wait. So on count, what case was he on pretrial on?
The violation of probation on the 1700636316 CF10A. Evidently, there might be some issues going on with restoration of competency, and the judge released him to pretrial in that case.
And when was he released to pretrial?
December 20th, 2018.
So the
pretrial was supervising him, not probation.
So the violation of probation came up, and the judge released him to pretrial supervision.
Yes.
Okay.
Instead of holding him in custody, he was released to pretrial supervision on the VOP.
All right. Well, what I'll
Exactly.
but right. All right. So I'll just leave it. So that who's his division judge? Do we know?
At this point in time, it's saying Judge Porth.
All right. So I'll leave everything in place. He'll go to Judge Porth tomorrow, and then a determination can be made there. Jorge Angeles.
Jorge Angeles.
Judge, Mr. Angeles, come on up, sir. Judge, he's coming up and he declined the service of public defender. He has private counsel, Mr. Victor Cooper. Richard Cooper.
I left a message for Mr. Cooper on his voicemail. I have not heard back from him yet, so I don't know what the court wants to do, if you want to leave him for the end of the docket, and hopefully Mr. Cooper will call me back between now
All
and then.
right. Oh, well, we're not far from the end of the docket.
That is true.
So, Mr. Angeles, an attempt has been made to call your attorney, and a message has been left there. We've not heard from him, so what I'll do is I'll recall you, I'll make you the last person and see if we hear from your attorney, okay?
Okay, thank you.
All right. Gene Anderson.
Judge, he's here. I haven't had a chance to talk to anybody else from, I guess, page 20 on, Judge, so I'm gonna need time to speak to.
Excuse me, may I speak?
No, talk.
All right, so then so I guess all the other persons that are left to be called, you need time to speak with them?
Yes.
All right, I'll be in a brief recess, and then we'll see where you are when I come back. All right?
Thank you, Judge.
Okay. Okay. All right, North Broward, Eddie Rancher.
Good morning, medical reset.
Okay, thank you.
Your Honor, do you know if PC has been found?
Not that I can see.
I just asked that the court can make a PC finding.
Is Mr. Rancher represented by the PD? Well,
I'm not sure. It looks like he's been medically reset all weekend, though.
yeah, Judge Lee had him on Saturday. And then, so I'll find probable cause.
Thank you.
And then when he's available, we'll have him come back for bond.
Thank you.
Just double checking, Paul, Ryan, or Conti, do you have anyone waiting to be magistrated?
No one at Conti, ma'am. Thank you.
Thank you.
You could recall Mr. Angeles, Your Honor.
Okay. Jorge Angeles.
He's approaching, Judge.
Okay.
Yes, ma'am.
All right. Mr. Reed, you spoke to his attorney?
Yes, Your Honor, I spoke to Mr. Cooper. Mr. Cooper does not represent Mr. Angeles on this charge as of yet.
Okay.
So we are going to, if he wants to represent himself, that's his option. But if he does not, the Public Defender's Office is willing to represent him this morning.
All right, Mr. Angeles, the attorney's name that you gave us, a call was placed to him. He said that he does not represent you on these new charges. And so your decision today is to either proceed on your own or if you want to speak to one of the attorneys at the jail from the Public Defender's Office.
Yeah, let me do that.
Okay, sir.
He's gonna go with y'all. Oh, I'm sorry. Hold on one moment.
Mr. Romero?
Yes, thank you very much, Judge.
Okay, so Jorge Angeles, sir, you're before the court. Count 1 is aggravated assault on an officer. Count 2 is use or display of firearm during a felony. Count 3 is possession of THC. Count 4, possession of cannabis 20 grams or less. Count 5, aggravated fleeing with injury or damage. Count 6, driving while license suspended. Count 7, unlawful speed. And count 8, failure to provide insurance. 9, failure to drive in a single lane. And 10 is a traffic KPS matter. Also for driving while license suspended. I do find probable cause as to all counts. And I will hear from the parties as to bond.
Thank you, Your Honor. I'm going to be requesting a $15,000 bond on count 1, a $10,000 bond on count 2, a $10,000 bond on count 5. Your Honor, first off, just the allegations by themselves, I have a great concern for the community with respect to Mr. Angeles. I would note that this incident occurred at approximately 3 in the afternoon on a Sunday afternoon in Broward. His driving pattern is a cause for concern to the safety of others. Ultimately struck a fire hydrant. At that point, he intentionally struck the arresting officer's vehicle in hopes of evading arrest and apprehension and arrest. All this was done while he was had a suspended license. He had a warrant for failing to appear in court for driving with suspended license. During this incident, he was reaching in the area where a firearm was ultimately found, which causes great concern, Your Honor, considering his own admission that his intent was to avoid apprehension from this law enforcement officer. And Your Honor, finally, all of these acts were committed while he's out on bond for DUI with property damage, where he caused an accident previously, and that was late January of this year, and a DWS, where once again, he was driving illegally, and he continues to drive illegally with no regard for the law. In addition to the bonds I'm requesting, Your Honor, I'd be also asking for pretrial release with a GPS monitor, a TAD monitor, no driving until further order of the court, and random testing. And no possession of any firearms, weapons, or ammunition.
All right.
Nothing further, Judge.
All right. So you're saying that he's out on bond on a DUI case?
DUI property damage and DWS, yes, ma'am.
And when was that what date was that arrest?
January 23rd of this year.
And Judge, Mr. Angelo just told me that the DUI that he's out, that's the, who he has representation with the private attorney that I believe that my colleague was trying to get in touch with.
Okay.
Judge, in reference to what's in front of you, we're going to be requesting a $5,000 bond on 1, $5,000 bond on count 2, $5,000 bond on count 5. Unfortunately, Mr. Angeles, from what he informed me, just lost his job. He was employed with a company called Boca Beauty for almost a year, where he was a barber. So right now, he informed me that the only person that can help post his monetary bond is his girlfriend. What he informed me is she cleans houses for a living. He lives in Cool Springs by himself, where he rents an apartment for the last year and a half, and his monthly rent is about $1,000. So, Judge, his financial resources, as you can see, are quite limited, and that's why he's requesting a bond of $5,000 on 1, $5,000 on 2, $5,000 on 5.
All right. The allegations in this affidavit poses concerns for the community, and as such, I am going to impose a bond. Count 1, $10,000. Count 2, $10,000. And count 5, $10,000. The standard bonds on the other counts will remain in place. In addition, he'll be on a GPS. If he posts his bond, he'll be on GPS. And I'm also going to impose a TAD monitor. Well, yes. Count 10, the bond of $500 will stay in place. All right, no firearms or weapons. And I think that's it.
Your Honor, the state also had requested no driving.
Oh. Definitely no driving. All right, good luck, sir. Gene Anderson.
Come on up, sir. He's approaching Judge.
Mr. Anderson, you're before the court for one count of possession of a weapon or ammo by a convicted felon. I do find probable cause.
Judge, I'd ask the court to take into consideration when setting bond for Mr. Anderson that he's in possession of one bullet. I'm not saying that that's okay, but it's one bullet.
Okay.
Your Honor, the state's requesting a $1,000 bond.
Okay. He's doing a lot of talking.
Judge, that's reasonable. Thank you.
All right, I'll impose a bond of $1,000. Lamont Jackson.
He's here present, Judge, I mean.
All right, Mr. Jackson, you're before the court for one count of petty theft. And I do find probable cause. Anyone wish to be heard as to Mr. Jackson?
Judge, Mr. Jackson's going to be asking the court if the court would consider releasing him ROR. He's said it's been a number of years since he's had contact with the criminal justice system. If the state can verify that, Judge, that's what we'd be asking. If not, Judge, then we're going to be asking the court to consider releasing Mr. Jackson on standard pretrial release. At this time, he's not working. He's on disability. He's 59 years old. He lives here locally in Fort Lauderdale with his wife. His wife doesn't work. Basically, they survive on his disability check. His monthly rent is $500. So at the end of the month, they really have basically nothing to live off of. So that's why financially, as you can see, he's indigent. So that's why he's requesting an ROR or in the alternative, be released on standard pretrial release.
Your Honor, I don't have an objection to pretrial. He's got an open municipal ordinance. I'm getting hits out of Georgia and Maryland as well as Broward. I'm not going to be asking that any monetary bond be set there.
All right, Mr. Jackson will be released to pretrial supervision services. Juan Rios.
Mr. Rios is approaching, Judge. Beautiful. I will.
All right, Mr. Rios, yeah, you're before the court. Count 1 is burglary of a dwelling or structure. Count 2 is resisting without violence. I do find probable cause. And I'll hear from the parties as to bond.
Well, Your Honor, I think pretrial has some information.
Okay.
Mr. Rios is currently on pretrial supervision in case number 19003282 CF10A, Grand Theft Auto, and operator without a valid driver's license. At this time, we're going to request a revocation of his supervision.
And, Your Honor, if I may, I'm not going to be seeking a no bond hold on the armed burglary. I am going to be seeking a $20,000 bond, though, and a punishable by life offense. I am concerned that he is breaking into a home while in possession of a knife, albeit a pocket knife, 4-inch blade, but that he's also committing this act less than 4 weeks after getting out of custody on a Grand Theft Auto and being placed on pretrial. I would note, I have nothing further, Your Honor, but I would ask, additionally, no matter what the court does, that you order no victim contact, no return.
Judge, we don't have an objection as far as the special release conditions, which the state has asked for. We're just asking the court to take this into consideration. Right now, he's looking for stable employment. What he does is he goes to the labor pool, and when he manages to get work, he gets anywhere from $60 to $80 per day whenever he works. So as you can see, his funds are very limited. We're asking you to take that into consideration, determining reasonable release conditions for Mr. Rios.
All right. Mr. Rios, it was placed on pretrial supervision. What date was he placed on pretrial?
March 9th, 2019.
March 9th, 2019. And within less than a month, he's now arrested on a burglar of a structure or dwelling. So as to case number 19003282 CF10A, I am going to revoke his bond, and as to count 1, I am going to impose a bond of $5,000. Count 2 is operating without a valid DL. I'll ROR him on that count. As to the new arrest, burglary, dwelling or structure, I am going to impose a bond of $10,000. No victim contact, no return to this location. All right, good luck, sir.
I'm sorry, Judge, what did you set the bond on count 1?
10,000.
10, okay, thank you.
Ralph Lanise.
Bonded, Judge.
Thank you. Miss Parks.
Morning, Your Honor.
Good morning, Mr. Parks. You're before the court for count 1, driving while license suspended, habitual, and count 2 is felony violation of probation.
Your Honor.
Yes.
I'm sorry, I'll wait till the court makes a PC determination.
Out of Dade County, the violation of probation is out of Dade County for DUI manslaughter. I do find probable cause.
Your Honor, I do recognize he has a no bond hold out of date at this point in time. That being said, I am concerned that while on probation for DUI manslaughter, he is driving unlawfully again. I'm requesting a bond increase on count 1 to $5,000.
Judge, considering he has a no bond hold out of Dade County, he's not going to be released. If he posts bond, he's still going to be transported to Dade. I'm asking for the standard bond to be kept in place.
All right. I am going to increase the bond to $5,000. Good luck, sir. Christian Lowe.
See you in a little bit. Do you have him on your list?
He's here present, Judge?
All right, Mr. Lowe, you're before the court for 15 counts of fraudulent use or possession ID of another person without consent. And then count 16 is possession of a counterfeit driver's license or ID. And count 17 is resisting officer without violence. I do find probable cause for all 17 counts. Does anybody wish to be heard? Well, does anybody wish to be heard?
Judge, hold on. I'll ask. Judge, can we see if his bond's been posted?
Okay. It's not showing in the system as yet.
Judge, then it will be shortly. He also gave me the phone number of his girlfriend just to make sure she already did it.
All right. The bonds on counts from counts 1 through 16 is $1,000 on each count. Count 17 is $100. Good luck, sir. Pierre Senat.
He's approaching, Judge. I've been informed he declined the services of public defender.
His cousin is present, Judge.
His who's present? All right, Mr. Senat, you're before the court for 1 count of grand theft, and count 2 is unlawful speed posted. That's a traffic infraction, not from magistrate.
Yes, ma'am.
All right, I do find probable cause. I'll hear from the state. Sir, is there something you wish to say to the court?
Yes, ma'am.
Okay. No, not you, Mr. Senat. I was speaking to your cousin who's in the courtroom.
Judge, I wasn't planning on making any requests for a bond increase.
Okay.
I was just going to ask, in addition to the bond, that the court order no contact with. One moment.
It looks like the business is Posh Cleaners.
Posh French Cleaners, yes, Judge.
Okay. All right. So, Mr. Senat, I do find probable cause. Your bond is $1,000, and I'm also ordering you not to return to Posh Cleaners.
Yes, ma'am.
All right. Good luck, sir.
Thank you.
Antoine Graham.
Mr. Grant, come on up, please.
And, Your Honor, before the court makes a finding, if I could be heard as to count 1.
Okay. All right, you can go ahead.
Thank you, Judge. I believe the arresting officer's intent was that he be charged with first-degree misdemeanor criminal mischief, not with the enhancements that have made this the current charge a felony.
Okay.
Some people consider casinos to be very religious places.
All right, Mr. Graham, you're before the court for count 1, criminal mischief. Count 2 is resisting officer without violence. Count 3 is trespass. Count 4 is a felony violation of probation. Count 4 is presented as criminal mischief for a church or religious place, but that's not the case, so we're going to find probable cause only for the criminal mischief.
I think the standard bond would be $100.
Just so you understand, yes. All right, so I am going to impose a bond of $100 on count 1 for me write it in here. For criminal mischief. And then you should be before your felony judge tomorrow at 9 a.m.
And Your Honor, even though he has a lifetime ban, I would just ask that the court make no return a release condition.
And just so, this is a Seminole.
It seems like he's been lifetime banned from all of their properties.
All right, so Mr. Graham, just so you know, you're banned from all the Seminole tribe properties, okay? So no return. All right, Tyler Ramdas.
He's approaching, Judge.
Got it. Just Michelle, if he's got anything.
Mr. Ramdas, you're before the court for possession of cannabis.
I don't think so either.
Over 20 grams. I do find probable cause. I don't hear from anyone in regards to bond.
Yeah, that's what I thought.
Judge, I believe this is a first felony offense, Judge. If the state can confirm it, I'm going to see if the state would have an objection as far as having Mr. Ramdas released straight ROR. If not, he gave me the phone number of his sister, and I intend to call his sister after court.
I don't have an objection to an ROR.
Okay. All right. Good luck, sir. William Capasso.
Mr. Capasso, come on up, please.
Mr. Capasso is before the court, possession of cocaine, possession of drug paraphernalia, counts 3 and 4, traffic infractions not for magistrate. I do find probable cause.
Judge, we're going to be asking for pretrial release. I'll see if the state has an objection.
With the random testing, I do not.
All right, Mr. Capasso, I will release you to pretrial supervision, and I am going to order random testing.
For illegal substances, correct?
For, yes.
Thank you.
Or what other? Okay. Juan Mendoza. All right.
What else we got?
Then Ethan Hopkins.
He's still on loan, Judge.
He's still on loan.
Yes, ma'am.
All right, thank you. All right, thank you, everyone. Happy Monday. We'll see you this afternoon.